Thanks for hanging out with us, tuning in with us, having fun with us.
Jackpot Cherry.
Murphy's Law. With me again, my good buddy, Chris Kuhn.
It used to be much easier when we were just talking about barbecue.
Thanks to all of our watchers, all of our subscribers. All right, welcome to a very special episode of Murphy's Law. Our good friend, Iron Pig attorney, illustrious Iron Pig attorney, Dave Delaney has decided to come back. We're about a year out from our last podcast that we did, just over a year, just from before. I just went back and watched it again the other day, from just before a Hunter hearing, before we got that awesome ruling from him, January 14th, right? 13th. Last year. So we've invited him to come back and explain a little bit about what is going on now with our petition with the Supreme Court and kind of some of the differences and what we're really focusing in on now.
Thank you. Always a pleasure to be here and a privilege to be here. My name is David Delaney, and I'm counsel for the Iron Pig. One of the main themes that we've always talked about is harnessing this information to be understood. One of the greatest hurdles that I think we encountered during the pandemic was what was going on. We'd wake up in the morning, there'd be a new rule. We had to do this, we didn't have to do that. Who's enforcing these rules? Who's issuing these rules? And we had no opportunity to get to the bottom of that because of the speed and the velocity of what was going on. So what I want to do is take this back to the beginning. These are simple but powerful concepts. And we go back to James Madison. James Madison was born in 1751. He's the father of the U.S. Constitution, which was ratified in 1789. James Madison was only in his young to mid-30s when he wrote the U.S. Constitution.
I remember you saying that on the last podcast, and I joked and was like, "Yeah, I'm behind the curve."
We are all behind the curve. Now, we had help with other framers to put that together. He was also our fourth president. So the U.S. Constitution begins with "We the people." But what is the Constitution? What are we doing here in a place like America? Well, we have a republic government. And what does that mean? Yes, we decide things by popular vote, but the people delegated the power to a central government because we don't wake up in the morning with our cell phones and simply vote on things every day. We need an organization, a republic, to do that for us, and that is the government. And without that, we would have chaos, even if it was by popular vote. So Madison could see that how the government ran in England, and it was run by the king. We discussed this in our podcast a year ago. The problem was the king wrote the law, he enforced the law, and he interpreted the law. Madison and others brilliantly broke that up because that is the power that we give the government, is the power to enact laws, enforce them, and interpret them. It's what governs a civilized society. So everyone knows that the government is divided into the three branches, separate but equal. The legislative, they write the law. The executive, they enforce the law. And the judicial, and they interpret the law. Now, Michigan is unique because it has a strict separation of powers. There is no sharing of the power. There's no delegating of the power. The power is vested in each of those three branches of government. What is the most important branch that we have? To me, it's clear that the most important branch is the legislative. They write the laws at the state level and at the federal level. And because of that, people like Jefferson brilliantly developed a very intense and multiple legislative branch. And for example, at the federal level, there are over 400 House representatives, and there are 50 senators. Those numbers are less in Michigan. But there's a lot of people that have been given the power by the people to write laws. And for those laws to become enacted, the governor or the president, which is the executive branch, has to approve that. So it is not easy to write a law. What's a law? A law is anything that's a rule for the regulation of society by the government, telling us what not to do, mostly, and what to do. It is the to-do laws that get our attention the most. Mm-hmm. Thou shalt not kill. Thou shalt not speed. We're okay with that. We're told what not to do. Those are easier. But when you tell us to do something, when you make us do something, that is where we push back the most. For example, having to wear a seatbelt. That law is on the books. It's now enforceable. We don't like it, but we do it. Having to wear a mask. Big pushback on that.
Yep.
I don't mind you telling me what not to do, but when you tell me to do something that's affirmative, I don't want to do it. As a result, Jefferson rotates the House of Representatives out every 2 years. Okay, so if you don't like what they're doing, kick them out of office. Yep. So the most powerful branch also is the most cyclical. So it returns the power to the people to get them out of office. So what happened during the pandemic? And really had been developing some time before that. We have what's called the fourth branch of government, and that is the administrative agencies. Who are they? The CDC, the EPA, OSHA, the health department, the schools. What branch are they in? The executive branch. What are they doing? They're writing laws. Why? Why does the executive branch want that power? Because they have the power of enforcement. They have law enforcement. They have the right to gain search warrants. They have firearms. Any of these agencies do and should carry those. But their job is to simply enforce the law. We separate that power. This is what Madison called tyranny. When one branch has the power of the two branches, and that's what's been happening in America. It's what's been happening in Michigan. We call this unelected power because the people at the agencies are not elected by Ian and other people. They are appointed by the executive branch. They're insulated from removal. Only the executive can control them. And the difficulty comes is when the health department or OSHA or the CDC, by a person you don't know who they are, wakes up in the morning and writes a law. That's it. No administrative process through the House, through the Senate, and then signed by the governor. During the pandemic, the judiciary was reluctant to invade that law writing because no one had challenged the fact that it was not proper for them to write law. The judiciary simply said, well, a law was written and I'm going to enforce it, which they do most of the time. They enforce the speed limit. Most laws are upheld. So how did that happen? That's the question. Well, this is called the non-delegation doctrine. That is, the legislature gave to the executive law writing power. Okay. Did they do that intentionally? Sometimes they did, and sometimes they did not. With the governor of the state of Michigan, under the Emergency Powers Act, the legislative branch in 1935 gave the governor power to write laws. That was struck down by the Michigan Supreme Court in a very heralded decision called In Re Certified Questions. Now, sometimes the legislature doesn't intend to give the executive the power. The executive takes it.
Yeah.
That's called usurpation. Yeah. Okay. So here's an example, a new example, the fire code. Okay. Here is an example of a hypothetical law, but it's based in actual law. The fire code says that for every 100 square feet of a business occupied by the public, no more than 50 people shall occupy that space at one time. Okay. So now you have a clear-cut law drafted by the legislature. If Ian doesn't like it, he picks up the phone and calls them and says, that's too small. I can do 75. Well, they can go back to the process and change that law. What does the executive branch do with that law? They fill up the details. That is, they determine the facts. They don't write the law. They just determine the facts. So the fire marshal comes in with the law written by another branch, and what does he or she do? They measure the room. Is it 100 square feet? Yes, it is. Then he counts the people. Either you have 50 or you don't. Mm-hmm. If you have more than 50, he writes you a ticket. Now, you still have the right to go to the judicial branch, the brilliance of James Madison, looking out for the people, to tell the judge 50 is an unreasonable number. And the judge can invade that. He's not likely to, or she's not likely to, the judge in that situation. but that's precisely how the law works. So now, what happened? The legislature wrote laws that sounded like this. The fire marshal shall not allow an unreasonable or only a reasonable number of people in a room that's 100 square feet. Okay, what's happened there? Now you've given the discretion to law writing to the fire marshal.
Right.
He or she gets to determine what's reasonable. So Ian says, the guy across the street, he's pushing 60 people on a Friday night. Well, I don't think with your location, Ian, and your fire escapes that you should have more than 50. Well, that's not fair. What is happening? You've got an imbalance of power there. Now, the other thing that happened is the legislature had that in there, that a reasonable number of people may occupy a space of 100 square feet. And the fire marshal may enter orders to effectuate that. They didn't intend to give law writing power to the fire marshal, but he took it.
Right.
Okay? Because you went to high school with the fire marshal and he never liked you, which is not likely, right? And so he took it. I know, right? He took it, or she took it. And they're going to come in like they did other laws called safety and welfare, these floating concepts, and they're writing the law. So where are we now? One of the things that we argue in our petition and application to the Michigan Supreme Court to cut through this are the vesting clauses in the U.S. Constitution and the Michigan Constitution and every constitution in every state in this country. The vesting clauses are very simple. Here is Article 4, Section 1 of the Michigan Constitution. The simplicity and the beauty of this is courtesy of James Madison. Legislative power is vested in the Senate and the House. That's it.
Yep.
It doesn't say they can share that power. And in fact, Michigan has a strict separation of powers. Not only does Michigan have a vesting clause for each of the three branches, executive power stays with the executive, judicial with the judicial, and legislative with the legislative. They have another whole section that says those powers do not cross under any circumstances. The location is mandatory. There's no sharing, delegation is prohibited, and every act of delegation is void. That's it. That's really all that people have to know when they look at this. That avoids all of this concept about what a reasonable law is and who wrote it and things like that. It's vested with the legislature. It's got to come out of the Capitol or it is not a law. Now, is there any relevance to this? Is this yesterday's news? Is this something that was argued 10 years ago? No. So January 13th of 2022 is when Judge Hunter released his decision severing and striking down as unconstitutional parts of the health code. Why? Because that health code said they can pass laws when necessary. Necessary is whenever they feel like it.
Yep.
We just talked about the fire code. It's going to have to define, the law must have said this, that they can close the Iron Pig restaurant when these things exist. Then all they do is fill in the facts. That didn't happen. Just says they can prevent the gathering of people. What does that mean? So that law has been struck down. So the same day, and that's a great story between you and I, when I called you to tell you about Judge Hunter's decision, the same day, the U.S. Supreme Court struck down the OSHA law on masking and vaccines. And you thought I was talking about that case. You said, I've heard about it. I said, no, did you hear about this one? And then I lost reception because you were skiing. Great story. But in any
snowboarding.
Oh, yeah, right. Yeah, I know. These northern activities, right? Who knows for the most part. So the U.S. Supreme Court is now onto these agencies, okay? So OSHA, who are they? That's the executive branch. That's an administrative agency. They were writing laws. They can't. It's vested in the House and the Senate. The legislature has that power. So what did OSHA do? They wrote a vaccine mandate and a mask mandate. Where? Well, those OSHA laws are thousands and thousands of pages. You're going to find something in there. Reasonable, necessary, health, safety, and welfare. Some just general concept to go with. Supreme Court said, no, you don't have that power. So they struck them down. It continued. In June of 2022, the EPA decision, okay, global warming, all those things, maybe those are all good concepts. But again, the EPA wrote law. That's the executive branch. They don't write laws, they enforce them. So that was struck down by the US Supreme Court. Now, 2023, the US Supreme Court, and they don't take many cases. They reject a significant number of cases, they accept so few. They've taken 2 more administrative cases. The FTC, the Federal Trade Commission, and the Securities and Exchange Commission. Mm-hmm. They're writing laws, and the Supreme Court is not going to accept that because the agencies are executive. They're writing the laws and they're enforcing the law. One of those cases, and we were talking about earlier, involves the right to a jury trial. In your cases, you never got a right to a jury trial.
Nope.
At the administrative level, with the Health Department, the Liquor Control Commission, the Food and Beverage, which is MDARD, all said no. When we got to the circuit court, no right to a jury trial. So what's the problem with that? The Michigan Constitution, which is not that long, although it just got longer, says that you have a right to a jury trial in a civil case. So how can that be? How can you not have a right to a jury trial, but the Constitution, which precedes every law in the state of Michigan, says you have a right to a jury trial? That's because the legislature unintentionally or intentionally began to water down the Constitution and unknowingly, and in some cases knowingly, let that power slide away over to the executive. But what brings that back into focus? The vesting clauses. The power stays with Congress, and it cannot be transferred. One of the things that I wanted to talk about was to simplify again and harness this information is back to what a law is. A law must be a law when it leaves the Capitol. It can't become a law. If it does, it's not a law. So that when it leaves the Capitol, Ian Murphy can pick it up, he can look at it, he knows exactly what he's supposed to do. He tells his staff, look, this room is 100 square feet. He tells the bouncers, we cannot have more than 50 people in here at one time. We're going to get a ticket. He knows what he has to do. Right. And he's responsible if somebody sneaks in the back door and it's 51. What if the law says that Ian can only have a reasonable number of people in the room? How many people is that? He doesn't know. He has to wait for someone else. So there it is. When it left Lansing, it was not a law. It's going to become a law. It must be a law when it leaves there. So in conclusion, here's what I would like people to think about when during the day, whether it's on social media, the news, or any place else they get their information, when they hear about a rule, okay, and again, a rule is anything that governs your conduct. Wear a mask, can't steal cars, any of those requirements. Which branch is announcing that rule? Okay. Is it a new rule? What's the rule? Okay. And who wrote it? Those are the only 2 things that you want to think about. Because when you're listening to all this, you're just being told, as we were during the pandemic, you have to wear a mask. Now, remember, it has to come from the government. Okay. So if Ian decides or a business decides you have to wear a mask in my restaurant, that's their choice. That's a private industry. And if you don't want to wear a mask, you can't come in their establishment. But when the government tells you to do it or not to do it, who's saying that? It can be announced by the executive. We're okay with that. But who wrote it? Did it come from the legislature? And is it clearly a law? Or did the executive write this law? Which is a lot of that is going on right now. These agencies in Washington, D.C. and in Michigan, and then with the pandemic changing, that has settled in a little bit. But they're still on the books. That's the problem. These laws are still there. And if you look at the law, you can find reasonable and necessary and things like that. The courts have to balance the branches again and simply return to the vesting clauses in the U.S. Constitution and the Michigan Constitution that says law writing stays with the legislature. And there's no further debate.
That's the biggest thing to me when we, again, we always say we're trying to make it easy for the guy on the other side of the bar to understand. And when hearing you say all this, because we've had so many of these conversations and all this stuff about the evolution of this entire thing, to me, it's as simple as when you say fill in the details. There's so much ambiguity to reasonable and necessary and safety and welfare that when I was down in Lansing a couple weeks ago at the state of the state, and you had texted me and we had talked about it. Like when you're talking to these lawmakers, tell them, make sure that law is complete when they send it out. And I did actually say that to 3 or 4 different senators because obviously they were asking why I was there and this, that, and the other. And we talked about the petition to the Supreme Court. And I did. I just told them, I said, listen, you guys should be upset about some of this stuff that they're doing because the executive branch is basically telling the legislative branch, you guys can't act fast enough. Therefore, I'm going to use all these other things. So firstly, they're telling you can't do your job. Secondly, we're coming in to tell you, you probably need to do your job a little bit better. Instead of leaving so much ambiguity on these things, take the time and make sure that the language is specific. 50 people per 100 square foot, not, a reasonable amount of people. That sort of specificity is really what needs to happen. And I frankly don't want to hear about any of these lawmakers complain about having to do oh, it's going to make this process even longer. So what? That's your job. Like that's what you get paid to do. That's what this entire thing is designed to do, is to make you create the best possible law that you can to send it out. Now, really what we're just trying to say is you guys don't get to send these things out anymore with all this ambiguity into it. And the courts hopefully will come in with the vesting clauses and say you no longer can delegate anything to any of these other branches. It's very fun to, the last couple of episodes, I've done some stuff on the whiteboard and, I'm a layman and obviously everything I get comes from you. You distill this down for me. So it is fun to listen to you describe it all again to our audience. But even to me, as somebody that, we sit and discuss these things quite a bit, it's still fun to go back and listen to how simple the vesting clauses are and the separation of powers in Michigan. And it is very simple. Like it doesn't have to be as difficult as these people have made it. The administrative, that fourth branch has grown so big that we're almost just used to it now. Nobody questioned anything. I shouldn't say nobody, never use absolutes, right? Most people didn't question the executive orders. Thankfully, some people did and were able to get certified questions. Thankfully, we had enough support to keep us going through this, and we had the health law also ruled unconstitutional. But we're not done because this stuff is continuing. We made the joke a couple of times, with the gas stoves and some of that stuff, and which is also ironic because, again, Senator Hoytenga, she had introduced a bill when she was in the House of Reps 2018 to ban any bill or any law that would ban gas stoves. And here we are 5 years later, and we're discussing it now. And this is an executive branch, a fourth branch agency that is coming down trying to tell you things. And we'll see more things with MIOSHA, I believe. Somebody just asked me the other day if have you heard anything on the petition? And it's like, no. Slow down. These are not things, and I didn't realize, you were just telling me before that, their caseload, if you will, or people that are actually petitioning, there are a lot of people that do petition the Supreme Court for silly things and for very important things. This is monumentally important. And I think the way that you crafted this is not just me blowing smoke, but the way that you have crafted this petition is going to make it very hard for them to not look at this thing. It's so basic and it has such great implications for reining in that administrative state and we know the comments that they have made about certified questions about our case before, I'm going to be wildly surprised if they decide not to take this case. And I would really want to know why. If they decide not to take it, do they issue opinion on why they don't take it, or do they just say we're not going to take it?
Well, you've already seen that. The State Department of Public Health petitioned the Michigan Supreme Court when Judge Hunter ruled immediately. And I think it's 4 of the 7 that have to vote internally to take a case, and certainly 4 of the 7 to take any action once it's going to be decided. But in that case, 5 of them said, we're not taking it at this time. And we want the Court of Appeals to weigh in first, which is very common. In re certified didn't go that route because it came from a federal court.
Right. Yep.
But in any event, 2 of the justices dissented. One conservative and one that would maybe not be conservative said that, no, we'll take it now. We need to answer these questions now. Particularly Justice Viviano wanted to have that heard, which was a key component to our application to the Michigan Supreme Court. So they will. Occasionally, you don't get that. You'll get 4, that voted not to take it, and the 3 that wanted it decided not to weigh in. You're going to get that 1-sentence rejection that we get at the U.S. Supreme Court and every Supreme Court in the state. We deem certiorari not appropriate in this case, and words to that effect. I don't think that'll happen. I think that they'll weigh in pretty heavily. Plus, in the in re certified question, the Michigan Supreme Court picked up on Justice Gorsuch in the U.S. Supreme Court. And what Gorsuch has said is that we as a nation have become untethered from the Constitution. We're creating this 4th branch of government. We're letting them write laws and enforce laws, and it is doing significant damage to the country. I want to get back to that, and in the appropriate case, we'll do that. Well, the Michigan Supreme Court said the same thing. They said we're going to apply the current test that we have now, which is the intelligible principle test, which means, unfortunately, that reasonable minds can differ. So, but the in re certified in a footnote said, we think that test is suspect, but it's the test that we have now. And you're seeing that now. You're seeing courts start to say, no, wait a minute. My definition of necessary is different from Ian's.
Right.
We cannot have that. So we take that out and we go to the vesting clauses and say, you don't have the right to write the law to begin with. That's the end. No amount of delegation is acceptable. So Justice Viviano, when he first got your case through the health department, said this is the sequel to what we talked about. And that was that the executive branch was using this anti-rioting law. And we think they're going to jump to the health department law. And they did very quickly. And this is something that we want to, Viviano cites Gorsuch and says, I agree with Gorsuch that we need to get back to James Madison's very simple but powerful concepts. There are 3 co-equal branches of government. They never shall cross into the other, and the power is vested. It's really as simple as that. So long answer to a short question, I know. So we're going to give them a chance to weigh in. There's another appellate decision that's sort of floating around out there, and they reached the lower court, Court of Claims reached the opposite result. They think that the health department has the power to write laws. Okay, we don't support that. That case doesn't cite the vesting clauses. It really doesn't address intelligible principle. But we asked the court to either join us with that case or hear ours. So we'll wait. That was only filed January 16th. It's only early February. Yeah. So I think that, we're going to, we'll see. But we have other avenues that we're going to be looking at here. One thing that I wanted you to address was what executive power looked like. And I'll put you in the right direction, and you know where I'm going to go with this. During the pandemic in 2020 and 2021, I think it was in 2020, the health department taped to the front door of the Iron Pig a law written by one person, not in the legislative branch, woke up and said, I closed the Iron Pig. I mean, basically indoor dining was closed. That was a law written by one person who's not elected, who's an administrative agent. As soon as that law was put into place, guess who came back? The executive branch. the same branch came back to enforce. And that was the Michigan Liquor Control Commission. That was MDARD, which issues your food license. And then OSHA was coming through too. And based on that law, they began to enforce with law enforcement. Police came here. Everyone's aware of what you went through on those things. So you lived under the thumb strictly of the executive branch. And the only time you saw the judiciary was when they took that executive law, which is not a law, and told the judge, this is a law. Well, this was a long time ago, and we really hadn't had our feet on the ground. So the judge enforced the law, but he was enforcing an executive law. There's no such thing. So tell us a little bit about what that was like.
Well, I'll start right at the beginning when you said that there was a law passed and the government didn't tape anything on my window. I was sent an email that said, here is this, you need to post this on any available entry. They never came and gave me notice. They never came and sent certified mail, nothing. If I hadn't checked my email, if I wasn't on social media, if I didn't watch TV, I would really have no idea that there was an executive order saying that this, that, the other. We did that. The first go around, we did everything. We shut down. We did takeout only. Barely made it through. Finally, we opened back up. Fast forward to the fall, right? We go through the summer with limited capacity restrictions, all that nonsense. And then the EPGA gets turned down, overturned, or, that basically stricken from law. And then 3 days later, they turned to the emergency orders from the health department. And that was October. We did our thing. Then another emergency order comes down where they start asking for names and phone numbers and the time that you're in the restaurant. And we immediately saw a drop off in business right then. Then another order comes out. Then another order comes out. We're creeping up towards Thanksgiving, and they shut us down completely. Takeout again only.
So the executive wrote the law, and then the executive enforced that law.
Yeah. And locally, right? Because it wasn't just the state health department, it was the local health department as well. That's who. So when we made the decision to open back up after a week of staying closed, we were given no guidance from the state, no unemployment suggestions for anything. The legislature goes on vacation and does nothing for us again. I decided to stay open, called the health department the day before and said, listen, you're kind of backing me into a corner coming up into the holidays. What am I supposed to do? I'm probably going to have to open the restaurant back up. At this time, people forget we also had a coffee shop. So I had 2 MDARD food licenses. I had our coffee shop shut down. They came in the very next morning at 11:30. We opened at 11 o'clock. 11:30, a health department official was here with a cease and desist order that had my coffee shop and the Iron Pig listed on there. So I knew right from Jump Street that they were way overreaching. And I said, listen, this is not correct. This other place, you didn't do any investigative work on this thing whatsoever. I never said that we were keeping the coffee shop open. So the local health department didn't have it. They had no idea what they were doing. And I even asked them, I says, what does this mean? Well, it can be up to $1,000 a day fine. Well, what do you mean up to $1,000 a day fine? And these other consequences, but mainly it was $1,000 a day, right? As operators, we look at our daily costs and go, well, I can't afford $1,000 a day fine. This is insane. That was very specific. So we go through this, and a couple of days later, the Liquor Commission comes in. They emergency suspend our liquor license down in Lansing, 5:30 at night. 2 hours later, Serpico's here trying to grab the license off the wall. Then it's the health department again. Then it's my OSHA. I mean, they just kept coming and coming and coming, all using 2253 as their excuse, their permission slip to threaten me with thousands. I mean, people forget. Yeah, they try to get us for 5,000. They said 5 days in that phone hearing, 5 days we were open, so it's $1,000. We were open in excess of 90 days. So they could have gotten us with a lot. I mean, we'd be done. We would absolutely 100% be done. A restaurant can't survive $1,000 a day fine. We knew that going into it, and that's why we risk it for the brisket, right? It's kind of the tongue-in-cheek thing about that. But it was one after another, right? The Liquor Commission, the Health Department, MDARD, MIOSHA. I mean, the amount of, you've seen my banquet table out here is just covered with documents, boxes and boxes of documents. They just drown us in paperwork and hearings and fines and threats. And that's not even discussing any of the social aspect, that pressure, that peer pressure from not just these other agencies, but other customers, other restaurants. We're doing our part. Why aren't you doing your part? And they created this atmosphere kind of based around fear, but mostly compliance. We're complying. Why aren't you? I have, to this day, and I certainly don't expect it, I have not had a single person come to me and say, I'm sorry, I was wrong. And I would never say, or you were right. Plenty of silly and, quite honestly, nasty things have been said about me and our business and how we could, put our community at risk and this, that, and the other. And this is where we brilliantly from the beginning never made this about COVID. It has always been about the language contained in this law: reasonable and necessary and certified questions, limit the gathering of people for any reason, and may establish procedures. That ambiguity is crazy. That health law is now severed. So if they want to create something similar, the legislature now has to create a bill with more details, right? They can't send this thing out for the governor to sign without filling in the details now. That 50 people per 100 square foot is a very identifiable fact that the executive branch can then look back on. They didn't have any of that stuff with us. And I just knew from the beginning that something wasn't right. Did I know that it was vesting clauses and separation of powers and any of this other stuff? Hell no. I'm not that smart. I just knew that something, I'd never seen anything like this before. I'd never seen the health department come out with anything. I've been in the restaurant industry for the better part of 20 years. And I've never seen this power grab like this. I even called our insurance company and says, well, okay, our insurance is going to take care of this, right? No. Nope. It's not an act of God. It's an act of government.
Yes.
And I was just like, I'm just blown away. Like, how is this possible that these people have this much power to come into my private enterprise and shut it down? I understand rules, right? Like you said before, there are laws that say we can do things and laws that say we can't do things.
Right.
And I think it's that part where they came in and said, you have to do this or else. And that just did not sit right with me at all. And it wasn't just easy to just go, hey, let's keep the restaurant open. Let's risk, everything that we have in our dream and our home and all of this stuff on a whim. I just knew fundamentally there was something just not right.
Let me add this, because you made a couple of really good points in that discussion. Back to the fire code. When you violate that fire code, the fire marshal takes really the case to the court immediately. So you get an immediate hearing before the court. The judge justifiably says this to you: Ian, when you opened your restaurant, it was already on the books. You knew the square footage, you knew the number of people. If you didn't like that law, either don't open your restaurant or enact somebody in Congress to change that law. But the difficulty was that Ian said the law is this: I can have a reasonable number of people, and that changes all the time. And then the fire marshal is saying that hypothetically, well, I'm also counting family members. Well, I don't. I mean, if you come with a family of 5, that's 1. So the law is not consistent and clear to you. The second thing, and this is what the U.S. Supreme Court is looking at now, is how much time you toil in the executive branch before a judge looks at this, okay? So the administrative agency comes in, They take your liquor license, they fine you, they take your food license, and you haven't seen the courtroom. No, wait a minute. Yes, I have. No, that's an administrative law judge. What branch is that under? The executive branch. Who appoints the administrative law judge? The executive branch. It's one-stop shopping.
Mm-hmm.
They write the law, they enforce the law, and they interpret the law. So you don't get a chance to come over to the judiciary until they're all done with you, which is what the U.S. Supreme Court is looking at right now, saying, wait a minute, the minute you write him a ticket for being open, we want him to come to the court. We want to look at that law immediately, and that's not happening now. At the federal level, you can be tied up in an administrative hearing for 4 or 5 years. That's half a decade. Lots of money, lots of time, lots of power, and you're all in one branch, okay? And they're on the same team. That is what you experienced. We spent all those hearings with liquor control, with the food license, with OSHA, with the health department, and we were in one lane. We were stuck in that lane. And by the time we got over to the judiciary, all the damage had been done.
Yeah.
Now, the judiciary ended up solving the problem, but we had to wait.
Yeah.
We didn't get a hearing. You lost your liquor license in January of 2021 or December. We didn't get a ruling until a year later.
Yep.
That's too long.
Yeah, it's crazy. And some would suggest that's kind of by design.
Yeah.
I may be one of those people, but it's that pressure brought to bear by all of these things, by basically 1.5 sentences in this law, and all the ambiguity around it is what has created this entire thing. Our solution is very simple. There is no such thing as a proper delegation from one branch to the other, right? It's pretty cut and dry. It's unbelievable to me how simple it actually really is. And the more I've been thinking about it since we've discussed the vesting clauses,
all right,
my fear is it may be too simple for some of these people. And these people I'm referring to are legislators, right? Because these are the ones that we actually have to get their attention again and say, listen, this is actually what your job is. You've been doing an okay job of it, depending on your point of view, but you're not doing your entire job, right? It's like our dishwasher washes the dishes, but then doesn't do the silverware. Like, you got to do the whole complete thing for the people to actually have a meal, because how are they going to know if they should be using this, that, or the other? Well, I'm just going to eat my spaghetti with my hands.
Right.
And that's essentially kind of what we've been doing, is fumbling our way through this friggin' spaghetti. And now this is kind of a terrible analogy, but we're bringing the silverware into the meal so it can actually make sense and can be complete, and not be so messy, I guess is really what I'm trying to say. Because this has been a mess, and will continue to be a mess, especially with the T&V ruling, that other ruling saying the health law is constitutional
and is a proper delegation.
It
says that delegation is allowed under the Constitution.
Yeah.
And it is not.
So I think we have to unwind a lot of people's thinking. Again, legislators, not just us, but the people that are doing things. We have to kind of unwind their thinking, because they have grown up in this system that has allowed them to, the DNR recently just passed a law, or there is a law now that allows the DNR to fine somebody for not reporting their deer within 72 hours or something like that. While it may be well intended for harvest counting or whatever the actual reason for this is, or to keep illegal deer hunting off, I don't know.
Correct.
But we're talking about fines.
Yeah.
And all these other things. And this is the Department of Natural Resources. They have a very important job, but should they have the police power when you're hunting? It's just these things. We have to remind these legislators, these laws need to be complete. When you caucus together and you create these things, get the details in there, work out the details. Don't leave the details up to the governor, whomever that might be, because it's not politics. That's the other thing. People want to think it's so much about politics, and it's not. It's about the fundamental function of government and how they're supposed to work together. And we've just allowed them to bleed together in the last couple of decades. And now it's time to say, The fourth branch is too big. It's time to rein this thing in. They can't be making their own laws anymore. They need to be more specific when coming out of the legislature. That's pretty much it.
The first sentence of our application to the Michigan Supreme Court, if you remember what it says, the first word, power, period. That's what this case is about.
Yeah.
That's it. It's about power that's been given, as you point out, to the executive branch to write a law in the future. Okay, the difficulty with that is it leaves Ian on the curb. He's sitting on the curb in front of his restaurant, and he does not know what the law is. And so he is vulnerable and doesn't know how to enforce it. What do you tell your employees about how many people can be in this room on a Friday night? You don't know. And it's going to change depending on who is in the administrative branch. And the legislature has to be clear about that. And there's always discussions about, well, during these pandemics and times of war, we can't act fast enough. Well, they'll need to go back and ask James Madison about it. This is the Constitution that we have. And so if they want to amend that, they can. And the legislature can act fast enough. The pandemic did happen overnight, but it didn't really happen overnight. It didn't come in on a Friday night and flatlined us on a Saturday. Right. It was progressive, and then it hit that fever pitch. And especially with electronics now, the legislature can vote by Zoom.
Yep.
Michigan's not that big. If you have to drive down to Lansing to vote on a law at midnight with the governor, you can do it.
It's insane to even think that. That was just an easy excuse for her to pull that EPGA lever, right?
Right.
I had a discussion with one of our senators when I was down in Lansing a couple weeks ago, and mentioned that to him. And I said, this is why they turn to that, because they think you guys can't do your job fast enough. And he kind of hemmed and hawed at it. I said, how long do you guys have to wait before you vote on something? Well, we have to have Open Meetings Act, 18 hours for something, this, that, and the other. And I was like, so you're telling me that you folks can't get together and potentially vote on something within 18 hours? Like, come on now, it's 2020 at the time, 2023 now. And it's just like, no, enough of that. You guys get paid very well. Stop with all the other nonsense. Make sure that and they still have it to this day. They fumbled around with 2253 after it was severed by Hunter,
right? And
they've changed it now, and I think it's new. It's supposed to go into effect March 29th or something like that. And it's insane to me that they're even trying to amend this thing that has now actually been severed from law. But this is the power that they want to have, and they want to keep this thing. Now, I'm not an alarmist, but people might be questioning why this might be important moving forward. There's always the possibility of another health crisis like the pandemic. We've seen the effectiveness of fear campaigns and tyrannical authoritarian rules and laws, right? Michigan is one of the hardest hit by these things. They can then use these levers that they have effectively used in the last 3 years to do kind of whatever they want to justify this health law. Specifically, if the health director deems that there is an epidemic, now he can decide, or she can decide, whatever an epidemic is, if it's clean air or dirty air, or if it's the smog coming out of your tailpipe or whatever it is. All they have to do is find a way to justify this crisis as an epidemic, and they can use this health law. We don't want that anymore. We need very specific terms on what that looks like, right? 50 people per 100 square feet. It literally is that simple. I don't know any other way to boil it down and make it so simple for a lot of these people.
Here's two additional concepts on this. Why didn't the U.S. Congress simply mandate masks on airplanes and, or more importantly, mandate vaccinations for employees in the United States? Because they have to be reelected every 2 years. They don't want to put their fingerprints on that and get a call from Ian saying, I'm not going to do it.
Right.
So who did it? The FAA. Okay, back to the executive branch, and they can wash their hands of it. And the same thing with OSHA. At the federal level, OSHA mandated the vaccine. Congress easily could have passed a law, especially with one party having control over the other. That's the way the law works in this case. It's what Jefferson intended. There might be a different branch at the presidential level or the governor level, and then a different branch down below. But the people control that. So if it's gridlocked, then the people have to fix it. But the people maintain the power in this case. So I think that that becomes an issue. Also, we've talked about the Emergency Management Act that has survived in Michigan. Okay, now under that act, the legislature has given temporary authority to the executive to close highways and things like that. But here's the difference: it's revocable. Okay, these other laws are irrevocable. 2253, when it was on the books, gave the legislature permanent authority, and the legislature let go of it to close restaurants. Under the EMA, it's good for 28 days. We talked, it's a close call. There's a vesting issue there. And if I was pressed on it, I would say the EMA is also unconstitutional. But I think that what happens is the legislature has maintained a glove on that and said, we're not giving you any law-writing power. It's a bit like when there's an accident on the highway. The police can close the road. They're not the legislature, but they're going to close the road long enough for there to be the emergency to be resolved. And the law then snaps back to the legislature. And 28 days is a pretty short period of time. How long is too long? Certainly we could debate that. But at the moment, the EMA, and it was looked at and in re certified, but the problem is the irrevocability of it. Okay, all these other laws are irrevocable, and they're on the books. There are other laws in the health code, OSHA, school codes, every place else, DNR codes, in which power either has been directly given to the executive or it's there for the taking.
So really what you're saying is in Michigan, it should have been 4 weeks to spread the curve, or not spread the curve.
Right, exactly. Flatten the curve. Flatten the curve. I know, we forget. But remember,
because that would have been within the 28 days, right?
The governor therein lies the issue. After the 28 days, it was re-upped. Okay, new law.
Right.
28 days, new law, and the Supreme Court said no. Michigan Supreme Court said no. The language was very well written that at the 28 days it terminates unless you have the authority and the approval of both houses. Can anyone say Thomas Jefferson? Thomas Jefferson brilliantly put law writing powers into many, many, many hands. Every 2 years, Senate's a little longer, because law writing is so important. It's the foundation of our republic, is when the government is telling you to do or not do something. And we still maintain control over that. Hence, these administrative agencies on the executive branch either been given power or usurping it.
So the last thing I'll say about the administrative having so much power and the appointments and the fairness, I hate that word, but we saw it. I've always joked that we failed our way to the top. We knew that administrative court was very swampy, so we knew, and we also knew that we couldn't question the constitutionality of the health law in any of those administrative proceedings. But we saw in those hearings, just towing the line. When we got outside, even in Ingham County, in that case with the Department of Agriculture, where I was found in contempt of court, even that judge who is elected, he was even reasonable, right? We always made the joke, nobody wanted to be known as the COVID judge, right? So early on, it was the fall of 2020. It wasn't necessarily that early, but we really only know of a couple of judges in Michigan that have been willing to take this on. And Hunter, was on the forefront of that.
Sheboygan, Judge Gauthier.
Right? Yes. He actually was before Hunter.
He was, right? Yeah, indeed.
So we knew that there were some out there, but my point is the comparison between the appointed administrative law judges and the elected judges, right? As soon as we stepped out into Ingham County Court, we got some fairness from the judge. He ruled against us, found me in contempt, but he at least had the foresight to say, okay, how does the Iron Pig get their license back? What is the path forward? Yes, they were naughty. We're going to fine them $1,500 or whatever it is. He's in contempt of court. Mr. Murphy needs to shut down his thing. But how is he going to get his license back? That I understood and was at least fair, right? Everything else was just like, nope, rubber stamp, nope, rubber stamp.
James Madison gave you a path.
Yeah, absolutely. And then again, the other example of that is when we finally got out of the administrative and appealed to the circuit court, Hunter was able to give his opinion. Again, another elected official that is responsible to his electorate. So you can see the disparity between these administrative branch judges that want to just keep you under their thumb versus actually getting a fair shot. Again, I hate that word, but
and Judge Hunter said, I am a co-equal branch of government. You're not the boss of me. And that's what we need to see is that particular branch exercising that authority. All the branches should exercise their authority, including the executive on enforcement. They're welcome to come in and enforce. That's what they are vested with enforcement. And so I thought that, Madison allowed the high tide to lift all the boats at the same time, which is what he intended in that case, which I think really needs to happen going forward. And the U.S. Supreme Court is saying that because you touched on the constitutionality. Before the liquor control took your license, the U.S. Supreme Court seems to be saying, now, wait a minute, stop, let Ian come over to the judicial and check on the constitutionality. Because here's the difference, and we've talked about this before. If the Liquor Control Commission took your license because of prostitution, underage drinking, or gambling, you know better. If you don't like those laws, go down to Lansing and get them changed. But you knew going in. But that's not what happened.
Right.
Anybody tell me if you know the song? The executive wrote that law the day before, and they all piled on. You had no notice. See, it's a due process problem and an equal protection problem. You're not getting notice of these things. Then Judge Hunter would have said, Ian, you were allowing underage drinking. The person has to be 21 years old. So we're back to the math again. But here, and those laws change day in, day out, day in, day out, day in, day out. And there's the tyranny. You got one branch exercising both two powers. They can't have it. They can't even have, you cannot have more than one. 3 is what the agencies have. 2 is notably dangerous.
It's going to be very, very interesting moving forward, seeing how this progresses. We're trying to get the word out to all the legislators right now. It'll be very interesting to see if, I'm hoping we'll get some amicus curiae happening. Maybe Mackinac will jump in. I'm curious, the legislature threw in a brief last time too. I'm curious to see now if they will again because of the change in leadership there. I don't really know how that works, but
my thought is let them weigh in. I do want to hear the other side.
Yeah.
I want to know what is incorrect, not just our analysis. Our analysis and that application is based upon standing on the shoulders of giants.
Yes.
This isn't something that Ian and David came up with. It's in the Constitution and is supported by great authority, including Justice Gorsuch and Justice Viviano. So we are just giving back to them what they've been asking us for.
Yeah. And again, to my earlier point, I think we actually need to remind them, not necessarily the Supremes, but our legislators, that they need to make these things complete. And this is why, and this is what has happened because of this. So that's kind of my job. I feel like now is getting the word out about this thing, and see what happens, and rein in some of these powers so we don't have this kind of thing happen again. Because there's a very good possibility of something happening like this again, or something adjacent to it that somebody down the road 10 years from now says, oh man, that Whitmer, she was very effective on doing this, that, or the other. We might be able to, it's a very interesting time. I've never thought that we would be involved in any of this nonsense 3 years ago. But here we are, already changed the law, and hopefully we can create an environment in Michigan where we don't have this top-down situation where we have the supreme leader telling us how to live our lives, no matter who it is, Republican, Democrat, alien. I don't, it doesn't matter, because it's not about politics. It's about just those simple words in that law, and we'll see what happens. I mean, here we are, 3 years later, a year after doing our last podcast, and we're now sitting here with an unconstitutional ruling and moving our way up the ladder, and we're fortunate to be in a position that nobody else has been in. Did we plan it this way? No, we'd be geniuses if we did, but we just happened to catch, the right flow in the river, jump in the river right at the right time. So,
what I appreciate is that the Iron Pig is out ahead of the curve because the administrative agencies are trying to take back this power. That's what's happening, and they're looking for places that are weak to do that. And one of those areas that was weak was called the intelligible principle doctrine, which basically indicates that reasonable minds can differ on the definition of reasonable and necessary. Vesting cuts through that.
Yeah.
And the Iron Pig has put the courts on notice that we need to look at this because it's a clear constitutional path to what James Madison intended.
I don't think that a lot of people are going to necessarily like it. I think there are a lot of people within all of these agencies that like or enjoy might not be the right word, but are very used to having that entitlement of power to be able to do these types of things. So I think there's going to be significant pushback when the Supreme Court says, vesting clause. Yeah, that's it. We're done. So it's going to be an interesting thing to see what happens when this all really, the flashlight gets shown on it. It's going to be interesting to see how it works its way through the system, if you will, with these agencies.
Yeah. Well, we're going to look at, the Supreme Court now has a path that we would like them to look at, but also the local courts. We're going to start looking at the local courts because the health law, for example, is divided into a state and local. So if Lansing doesn't pass a health law, we know now that the local health department could, and the schools can. So you've got these smaller agencies that can effectively work together instead of one agency, similar to the school mask mandates. You had the health departments in each of the various counties issuing the mask mandate under the same law. And you had the schools. What did the schools have? The schools had a section called reasonable and necessary. I think we've covered this. Did the legislature give mask law power to the schools? No. In our view, they usurped it. They found a provision that says the school shall have reasonable and necessary procedures. That's all that it said. That's unlimited law writing. Is that a law that left Lansing as a law? If I handed you that code and said to you, here's the school code, make sure that the students are reasonable and necessary. There's no limitation on that. It's vaccines, it's social distancing, it's masking. If Lansing wants children in schools to wear masks, then say it.
Right.
The legislature should say children shall wear masks under these identified circumstances. And there come the facts from the executive. So the executive has to go in with great specifics and say we can mandate a mask when these 15 things are occurring. Okay. Now you can pick the phone up and say, why'd you pass that law? I don't like that law. I'm not going to vote for you again. So it's power with responsibility that you're looking at. And that's not what we have right now. And so even if another fantastic aspect of James Madison, even if Congress passes that law mandating masks for children in school, we still get to go to the court and say that's not reasonable.
Right. The remedy. Yeah.
Precisely.
In that specific instance with schools and masking and all that stuff, there was no way that the legislature was ever going to pass anything that was going to put masks on their voters' children. There's no way. They get unelected the next cycle so easily. So it's much easier for them to just say, "Oh yeah, let the health department over there make the bad decisions." Because when they get pissed off at Bob Gordon, they can just be done with him and give him a nice golden parachute or whatever it is.
Look how the branches warred over that warring. I believe it's Public Act 87 said that a local health department may not pass a regulation or a rule local health departments cannot mask children in schools. If you do, you lose your funding.
Yeah.
That bill was signed by Congress, and it was signed by the governor. After it was signed, the executive branch said it's unconstitutional.
Imagine that.
And the court hadn't weighed in. It has not weighed in. And we were going down that road, if you will. And then the mask mandate got rescinded, and we got into mootness, which is a topic for another. We're not going to delve into. Okay, let's go to mootness now. On that type of thing. But you see that the branches still, in the end, are like juries. They work it out, and if the three of them operate at the same level, then due process is served.
Well, I think that's probably a great note to finish everything on. Hopefully we've covered enough to make this hopefully make sense to other laymen's like me out there. I appreciate you taking the time to put all of this together. The brief is brilliant, and I have a feeling that more and more people will see that and realize just exactly how simple it is. So thank you for your time, everything that you have done. Thank you for taking the time to come explain this. Hopefully we get to do this more than just once a year.
I know we do meet a lot, but we don't often do these types of podcasts. And
well, we can't film our conversations because we're just too frank.
That may be true. And our goal really is for the people. As Madison said, we the people, is to harness this and to simplify it. And back to where I concluded a short while ago, which was who's announcing the rule? Which branch? And who wrote it? So you can harness it and bring it in. And if it's not written by the legislature, it's not a law.
Yeah, it's that simple. Just that simple. All right, buddy. Thank you as always. I appreciate you coming on. Thank you guys for watching this episode. If you haven't already, smash that follow button, subscribe. We're on Spotify, YouTube, Rumble, iHeartRadio, anything out there that streams audio or video. We are on that platform. Lots of information on our website as well of all of our previous episodes. Go back and watch the Supreme Court Brief 101. Might make this episode a little bit more understandable. Not that you didn't already bring it down so simple, but a little bit more detail is involved in that one with some of the specific sections of the brief. That's on our website, murphyslawdcast.com. Once again, buddy, thank you so much. I appreciate you.
Thank you for having me.
All of you.